Good afternoon, everyone. Welcome to the Indian Citizenship Act of 1924 webinar. And thank you to our panelists, Professors John Tahsuda, Bethany Berger, and William Bauer for lending us their expertise. I will go into their bios. Professor John Tahsuda is a distinguished fellow and adjunct professor at the UNLV Boyd School of Law, where he teaches federal Indian law. He has nearly 30 years of experience in matters affecting Native Americans and tribal governments as a former Principal Deputy Assistant Secretary of Indian Affairs, where he also became an advisor to the Secretary at the end of his tenure in 2020. Further, he has also served as the staff director of the U.S. Senate Committee on Indian Affairs, General Counsel and Legislative Director of the National Indian Gaming Association, General Counsel for the Oneida Indian Nation, and Adjunct Professor of Law at Cornell Law School. John is dedicated to applying this experience and knowledge to the advancement of tribal sovereignty and the betterment of tribal communities. Professor Bethany Berger teaches American Indian law, property, tribal law, and conflict of laws at the University of Connecticut School of Law, and is one of the leading federal Indian law scholars in the country. She is a co-author and member of the editorial board of Felix S. Cohen's Handbook of Federal Indian Law, which is the foundational treatise in the field. And she's a co-author of leading case books in both property law and American Indian law. Her articles have appeared in many prestigious law journals and have been excerpted and discussed in many case books and edited collections, as well as in testimony before Congress. Professor Berger has served as a judge for the Southwest Intertribal Court of Appeals, as a visiting professor at Harvard and the University of Michigan Law Schools, and also, most importantly, co-authored amicus briefs in 5 successful cases in the U.S. Supreme Court. Dr. William Bauer is a professor of history and program director for the American Indian and Indigenous Studies minor at UNLV, and teaches classes on California Indian, American Indian, and American West history. He is also UNLV's faculty liaison to the Newberry Library's Consortium on American Indian Studies. He is the author of We Were All Like Migrant Workers Here, Community and Memory on California's Round Valley Reservation, 1850 to 1941. A prolific writer, Dr. Bauer has also published essays on California Indian history in publications such as the Western Historical Quarterly, Native Pathways, and a companion to California History, plus an introduction to a revised edition of McGillivray of the Creeks. His current research focuses on the way in which California Indians used oral traditions to offer an alternative telling of 19th and early 20th century California history. Please be sure to give them a welcome. As we go forward discussing the Act, please enter your questions as you think of them in the Q&A tab, and we will answer them at the end in the order that they are received. If something particularly resonates with you, also feel free to use the reaction tab. So let's get started. To all our participants, oftentimes when we speak about American Indians or Native Americans, people oftentimes think of this designation merely as a racial class. Professor Tahsuda, can you begin our event by explaining the unique status that Indians enjoy and how that came about?
Certainly. Let me say thanks for having me here, Carla, and letting me participate in this. I think one of the important points as far as sort of an introduction into who Indians are is to think of them in the context that we started this country. So colonialism / conquest, however you want to phrase that, that sort of sets the stage for the relationship and what does being an Indian mean in under U.S. law. So we think about that way, and it brings us to this unique status. So why are they unique? Because and I would note that um, unlike other races of people, the founding fathers did not have a problem thinking of Indian people as persons. They just weren't sort of equivalent persons, and so, in a large part, that's because of this concept of the savage. They were deemed to be savage, uncivilized, but certainly were thought to be human enough or people enough that they could be moved to civilization. And so if you go back to their earliest writings, there's always this sort of concept coming from traditional international law about what conquering or colonial nations owe as a responsibility to the native people that they find. And one of those is to help them become civilized. And at the time, that's sort of equivalent also with the notion of Christianity, right? So, civilized people are Christians, and so there was sort of this that the efforts go hand in hand, and that's why you see a lot of heavy involvement by churches, missionaries, etc. But in a large sense, that was part of the big effort to civilize Indians, and so. Until they're civilized, then the concept at the time was that you can't bring them sort of into the fold of American citizens because Americans are all civilized. But that again, that doesn't mean that they can't be. So what that does in practical terms and legal terms is sets up this dynamic where the United States, while being responsible for these people, is not responsible to them as citizens, but they're responsible to them as this separate legal group under international law. So they can treat them differently. And unfortunately for Native people, that treating differently often serve the purposes of the colonial power, the United States in this setting, but it carries forward through time. And so even though a lot of things happen that we look back now and think were wrong, it shouldn't have happened that way, it set up this dynamic that we now have under U.S. law in which Indian people, as members of Indian tribes, are a separate and distinct group. And so the United States can treat them differently. The United States can take actions um, that involve them differently than it can with racial groups. And so we see things like special criminal laws that apply only to Indians. The United States can act specially to protect, even differently, the religious freedoms and rights that Indian people have. And so there's a lot of unique things that came out of that, some positive, some negative. One of the biggest, of course, is the trust responsibility, a very unique responsibility that the United States has. So that sets up this dynamic. But at the same time, and I know you're going to get into it, at what point do then they get to become citizens? At what point are they civilized enough to become citizens? And for the academics, that question, then does that change the dynamic once they become citizens and they're quote civilized? How does that impact these special powers and responsibilities that the United States has?
All right, Professor Berger and Bauer, would you care to add anything onto that? All right, with this context in mind, and like you were saying, Professor Tahsuda, we as American Indians entered many treaties. So Dr. Bauer, would you please establish the historical setting for the first Native citizens?
Yeah, thank you for the question. And Carl, thank you for inviting me to serve on this, to participate on this distinguished panel. And I think I'd like to also add that, right, I'm speaking to all of us from Southern Paiute land here in Southern Nevada. All right, so one of the original forays or the original emphases for citizenship for indigenous peoples in the United States kind of dates to the era of the development of the policy of Indian removal in the 1820s and the 1830s. Kind of before 1828, the United States roughly kind of adopt kind of a policy of voluntary removal, that if indigenous peoples wanted to leave the eastern United States voluntarily of their own choice, they could do so. They would negotiate perhaps treaties with the United States for that. But with the election of Andrew Jackson in 1828, the shift of policy shifted from a voluntary removal to a forced removal, that the United States would begin to force indigenous peoples to leave the eastern United States and move west of the Mississippi River. The idea, or the argument that Jackson and many others put forward, is that they did not believe that American Indians, as wandering peoples, as kind of savages, could not live together with civilized Americans. That if indigenous peoples continued to live east of the Mississippi, they would vanish and disappear. And so Jackson and many others kind of argued that it was in the best interest of indigenous peoples to move west for their own protection and for their own good, and they might one day kind of grow up to be citizens of the United States. I mean, I think we should know that this is just a cover for what the United States has always wanted from indigenous peoples: the land. But in order to kind of to force indigenous peoples to move west, the United States negotiated a number of treaties with indigenous peoples. Right. So as noted in the Constitution of the United States, right, treaties should be the supreme law of the land. Right. They're kind of encoded in Americans in the United States legal structure. And the United States negotiated many treaties, kind of the more famous treaties, with the 5 nations of the southeastern United States, right? The Cherokee, the Choctaw, the Chickasaw, Creek, and Seminole nations to move west. And for the Choctaws, their treaty was the Treaty of Dancing Rabbit Creek. And a lot of these treaties, including the one with the Choctaw, there were provisions included that allowed for Choctaw and other indigenous peoples to stay at home, to stay on their homelands, right? So many indigenous peoples did not want to be removed. The more famous example, right, is the Cherokee Nation, who resisted, right, removal, going all the way up to the Supreme, bringing lawsuits against the state of Georgia, up to the Supreme Court of the United States. But what these removal treaties provided is that if indigenous peoples wanted to stay on their homelands, they could. They would receive some land, a small parcel of land that they would own as private property, and then they would become citizens. The problem is, I mean, I think kind of the idea there is that it required indigenous peoples to relinquish membership or association with their larger nations, like, to relinquish membership or association with the larger, say in this example, Choctaw Nation, in return for small parcels of land and, right, the benefits of United States citizenship, however we might kind of articulate that. I think in general, what we can kind of see here is this is kind of emblematic of how the United States kind of, I would argue, kind of views indigenous citizenship. It is it is a one way in which to kind of to eliminate indigenous nations and indigenous people within this kind of broader history of taking indigenous people's lands. And so we see this kind of, I think, important kind of connection between kind of removal policies and indigenous citizenship kind of throughout kind of the 1830s and 1840s. And I think you'll see this continue even after the era of removal, with treaties signed with various nations that include this provision that indigenous peoples could have land, again, small parcels of land held in private property. They would become citizens, but it would require them to surrender their association with their nations and to kind of to look as if they're no longer kind of indigenous peoples anymore. So it's kind of part of these policies or these efforts to eliminate indigenous peoples in the United States.
Thank you so much for that. If anyone has any, Professor Tahsuda or Berger, if you'd like to add anything onto that. All right. Thank you for that broad historical outlook there. Going through history, also in 1857, we see that the Supreme Court ruled in Dred Scott that Native people could become citizens, like you were saying, through naturalization. So then what happens is we have this hodgepodge path to citizenship. Then in 1868, the 14th Amendment to the Constitution declared all persons born or naturalized in the United States and subject to the jurisdiction thereof were citizens. However, in this case, the jurisdiction requirement was interpreted to exclude most Native Americans. Then in 1870, the Civil Rights Act of 1866 was ratified by Congress, repeating this exclusion. So looking at this hodgepodge path to citizenship, Professor Berger, I enjoyed reading your paper on birthright citizenship. Can you please talk about the first or perhaps most famous Native person who sought citizenship and the ramifications thereof?
Sure. And thank you for inviting me to participate in this. And I'm speaking to you from Algonquian land, particularly the land of the Tumsis and Podunk on the Connecticut or Long Tidal River, which obviously gave its name to the state of Connecticut. As Carlos said, maybe some of the most famous, because we don't have records of all the citizenship seekers. And in fact, I think probably most Indigenous people at this time would have rejected citizenship, just as the Cherokee did in bringing Cherokee Nation v. Georgia, saying we are aliens not owing allegiance to the United States, because for the US at that time, as Professor Bauer said, accepting citizenship was rejecting any of the special tribal rights and relationships. And that only began to change toward the end of the 19th century, and then to more clearly change the beginning of the 20th. But one of the most famous early seekers of citizenship was Eli Parker, a Seneca man also known as Donahoggawa. I'm sorry, I can't pronounce it right, but who was obviously a traditional Seneca man, descendant of great leaders, himself a sachem, who was fluent in both Seneca and English, studied for the New York bar, but was prohibited from sitting for the bar because he was, they said, as an Indian, he's not a citizen, and that then when the Civil War broke out, he tried to enlist, perhaps even raising an indigenous contingent to fight, and was again rejected because he was not a citizen. Then he brought a petition to Congress saying, I'm doing everything. I am so qualified. By then he was like an engineer helping to build canals across the United States. And Congress said, sorry. And finally, friends put him in touch with then General Ulysses Grant. He got a commission. He became Grant's personal secretary, rose to become brigadier general, and wrote out the terms of the surrender at Appomattox. Another super famous citizenship, the one that got to the US Supreme Court that I included in my article, was John Elk, who was his tribal affiliation wasn't even mentioned in the Supreme Court case or any of the briefs, but I think I've got pretty good evidence that he was Winnebago. And why was he seeking citizenship? I think it was partly a test case brought by these reformers that thought, oh, if we just let them, all of these Indians are going to want to assimilate and be just like us. So we should encourage them to do that. But also for him, as a Winnebago or Ho-Chunk man, in his life, so his parents were born in Wisconsin, forcibly moved to Iowa. He was born in Iowa. Then they were moved one place in Minnesota, and then they were moved another place in Minnesota, had to leave Minnesota after the Civil War after and the Dakota Uprising, and then moved to South Dakota where they were on Sioux land and really miserable, and then finally fled to Nebraska and got land there. And then they started to allot the reservation in Nebraska. And he, by the time he brought this action, had fled there to the banks of the Omaha River and is probably saying, federal government, just could you leave me alone? And citizenship probably meant something like that to him. By the end of the century, the US was extending citizenship, as we heard, through allotment and through other things. But at the same time, they started taking back the rights. They said, well, we're going to make everybody citizens, but that doesn't mean they can vote. And it doesn't mean that they're going to be free of federal domination. And then we finally get to 1924 and the Citizenship Act that brings us here today.
Thank you so much for that. That was amazing. What I found out from your article as well is that the Elk versus Wilkins case reaffirmed the exclusion of Native people from US citizenship. So then, prior to 1906, I have found out that naturalization courts had little or no guidance on how to apply or administer the law. The law stated only that an applicant shall declare an oath that he will support the Constitution of the United States. Dr. Bauer, can you speak about what tribal citizenship meant and means for Native people, and describe what took place during a Native citizenship ceremony that differed from others?
Yeah. I mean, actually, so I think that the two questions that you're asking here, I think one, right, I think what we see as a tension between kind of indigenous citizenship and indigenous membership, as well as this kind of ceremony, right, the so-called shot your last arrow ceremony, excuse me, are kind of part of this another kind of change in kind of federal Indian policy that Professor kind of Berger was kind of speaking to as well. That we see kind of in the late 19th century. In the late 19th century, you see a lot of reformers becoming kind of quite upset or kind of critical of the reservation system, right? So reservations across the United States are established kind of the mid 19th century. They were intended to kind of reserve lands for indigenous peoples, and then kind of separate indigenous peoples from the rest of the from Americans. The goal there is that once Native peoples were kind of separated, kept off onto these land bases, then they could be kind of trained to become citizens to assimilate into American society. And in part, right, that's the basis for the Supreme Court decision in Elk versus Wilkins. The Supreme Court says that Congress had never passed a law authorizing Elk to be a citizen, and nor did they make any treaties that provided for Elk to be a citizen. Therefore, he couldn't kind of make this decision on his own. And the court says essentially, right, what the United States is doing in the 1880s is training indigenous peoples to become citizens. The way in which they begin to train indigenous peoples to become citizens is through the off-reservation boarding school system. That's a product that was kind of created because because reformers were arguing that schools on reservations weren't properly kind of teaching indigenous children the right kind of skills, and they weren't doing the kind of the rapid work of assimilation that reformers wanted. And the other that was mentioned is the policy of allotment. That was kind of right, surveying indigenous people's reservation lands, distributing that lands to heads of household, and those land allotments were held in trust for a period of 25 years. And then after that 25-year trust period ended, indigenous peoples would become citizens of the United States. And so there's this training effort to kind of make indigenous peoples citizens. So in the mid-19 teens, the Secretary of Interior, Franklin Lane, kind of begins to develop these elaborate, essentially spectacles that would kind of advertise, kind of almost kind of usher in or graduate indigenous peoples into citizenship. And so one of the kind of the first examples of this is with Lakotas on a Yankton reservation in South Dakota, is that the Secretary of the Interior, Franklin Lane, kind of goes to the reservation. He distributes fee patents, or essentially kind of certificates of private property, to allotments to Native peoples, and then begins to kind of grant them citizenship. And so there's this kind of elaborate ceremony that goes through this process, is that like the people would give on this reservation, Lakota people, their last arrow. They would shoot the last arrow, and then Lane would deliver a speech. And if I can, right, the speech said something like this, right? This act means that you choose to live the life of the white man. This white man lives by work. From the earth, we must all get our living. So after giving this kind of this speech, people would receive new name. They might receive a new name. They would receive a badge, right, declaring their citizenship, and more speeches. And then this process was highly gendered too, and so that women might also participate here. They might give a speech, so that the excerpts of a woman's speech would be, quote, "This means that you have chosen the life of the white woman, and the white woman loves her home. The family and the home are the foundation of our civilization. And upon the character and industry of the mother and the homemaker largely depends the future of our nation." End quote. And so in addition to the badge, indigenous women might receive like a sewing kit or something along the lines that kind of speaks to kind of the gendered kind of instruction that they might even encounter in boarding schools. I mean, it is an elaborate and kind of not like kind of an elaborate ceremony, right? So Lane actually kind of thought that it would kind of generate support for Native peoples to vote for Woodrow Wilson in upcoming elections. And so I think we can't kind of separate it from these kind of larger kind of historical contexts. But this is not necessarily the way in kind of indigenous peoples kind of understood this offer of citizenship. And kind of if I can kind of briefly, I think kind of a group called the Society of the American Indians, which was kind of led by highly educated kind of urban Indians in the early 20th century, was also advocating for citizenship. They too were critical of the reservation system, but they don't necessarily use it to assimilate into American society. I remember, like, one of the leaders of the Society of the American Indians was Dr. Charles Eastman, who's Dakota. He was a medical doctor. He was at Pine Ridge during the Wounded Knee Massacre in 1890. But he was a prolific critic of American civilization. I mean, he remembers, right, traveling to Chicago and being kind of aghast at kind of the levels of poverty and the kind of some of the problems associated with what was called civilization. And so he kind of, I think, famously claims, right, so that he wants to maintain his Indian identity, but he also wants to become American. He wants to take advantage of those aspects of civilization that would go back so that he could help out other indigenous peoples. And I think in part too, it's this drive and effort to, as Professor Berger mentioned, get away from the kind of the wardship status. So citizenship could mean for Native peoples that they could retain, they still are Native, still are indigenous, but maybe are not kind of being bossed around by the Bureau of Indian Affairs. And so I think again, I mean, so like indigenous peoples thought of their own citizenship in the early 20th century very differently than the reformers and government officials were thinking about it at the same time.
Such a fascinating history. And I loved in those ceremonies for Native people that the wife was given a purse, the man was given a plow. And I think, more than anyone, since natives are attached to the land, they were very cognizant that they got their living off the land. So, Professor Tahsuda, I was wondering if you could tell us more about the events leading up to the Indian Citizenship Act, and such as, the allotment period and the person who introduced it in Congress. And then can you please tell us sorry, this is a compound question. How many people it benefited, were benefited by the gift of citizenship?
How many people were benefited from the gift of citizenship? Oh, that's a loaded question there. So I think that one thing you can say is that sort of at the turn of the century, and in the early decades of the 20th century, there was some recognition of complications that came out of this having this group of people that you were responsible for, but were different, weren't citizens, they were different, and so I think that there were several things sort of emblematic of that. And you can start all the way back with what we call sort of the end of the treaty period, right? When the House of Representatives decided that they were tired of funding these treaties that the president and the Senate were entering into without consulting them on how much it was going to cost and stuff like that. So, sort of beginning that time, this dissatisfaction with the structure of how the United States had dealt with Indians and tribes up to that point. And then you roll forward, we have things like, the Crow Dog case, in which there's dissatisfaction with how Indians are thought to have, special, exemptions from criminal laws that civilized people live by, protected by the Supreme Court. So they passed the Major Crimes Act, so you see these things coming, but it's interesting, of course, that they have to pass them, in unique circumstances. Again, these are things that are particular to a race of people, but because we've created this special legal class called a political entity, and we're dealing with these tribes as entities, they're empowered to do this sort of extra constitutionally, I think of it, and sort of outside the normal restrictions of the Constitution. So so you have this sort of dissatisfaction with the structure, and then a growing realization of how as American society is becoming more complicated as you move from the 19th century into the 20th century, that this is making it, this context is even more complicated because these people aren't citizens. They're not citizens of the United States. They're not citizens of the states that they reside in. And in fact, the states are, according to the Supreme Court, the states have virtually no power over them, and no power over the land that they live on. And so, you have, and part of that is, I think, this impetus into the Dawes Act, of course. There is, as always, multiple interests going on. There was a continued desire, of course, to acquire Indian land, with this sort of background Adam Smith notion that the Indians aren't using the land the most useful way. If they were more civilized, they would. So we'll take some of the land, or a large part of the land, and give it to civilized people so that they can use it productively, because that's better for everybody. But we'll continue to teach the Indians how to become productive with their land. And when they do that, then they'll be able to be productive like non-Indian people on a smaller piece of land. I mean, remember, at the time, there was a great dissatisfaction that you had a few thousand Indians occupying literally hundreds of thousands or millions of acres of land. And, most, if you think about, most of the politicians are in the Eastern United States, where they're looking around, and farmers there farm, a few hundred to maybe 500 acres, and they think of them as being productive then. So it's deemed a great waste of resources. So again, dissatisfaction with the current structure of things. So the Dawes Act moves forward. I think that Professor Bauer and Berger, they'll point out as well, one of the things I think you draw from this is that there's always been multiple interest groups who have floated around, these ideas, these policies, these, changes in the law that come. And some of them think of themselves as the friends of Indians. Some of them are very self-interested, and some of them are looking sort of in a larger context about the continued advancement of the United States across the continent, et cetera. And so, lost in that, of course, is the Indian voice himself. But you have these different interest groups, and they have different ideas, and they kind of war with each other until you find something, again, to use the Dawes Act as an example, they kind of come together, and it fits the purposes of several groups, right? Those who want to get the land out of the hands of the Indians who aren't using it well, using it, in good economic terms, and put it to better use. And those who think that this is really holding the Indian back from being civilized, and they really think that that's the best thing. They really feel like they have the Indians' interest at heart, but they both now see this this allotment as the way to accomplish both of their ends. And so and I think really that is the impetus moving towards the notion of citizenship. Then you have sort of both folks, the friend of the Indian, I won't call them the foe, but sort of the self-interested folks who think that at the end of the day, now we need to move these people out of this special situation so that they will be subject to states, the laws of the states, the laws of the federal government, et cetera, just like everybody else. What does that mean? We have to make them citizens of the United States and citizens of the state in which they will be now residing. So that I think is sort of this impetus as you see we move forward into the Citizenship Act. And I think it sort of emblematic also of this in almost a humorous way, although it was very serious at the time. But in World War I, there was questions about whether Indian men who weren't citizens could serve in the U.S. Army, and the Iroquois, the Haudenosaunee Confederacy, actually declares war on Germany themselves, so that their men can be empowered to be enlisted in the United States Army. And so, it's kind of it almost seems like a humorous anecdote now, but at the time, this was a complication in their way of working around it. So at the end of the day, I think all of this stuff kind of pushed everybody towards this notion of citizenship being this answer to all the things of bringing the Indian along into civilization. At the same time, the goal of many is to remove this special legal situation that they're in and the complications that come with that. And so that's, sort of evolves into this effort for citizenship. And I think you noted that, or you wanted to note, one of the author names on the Dawes Act is Charles Curtis, who is, of course, rose to be vice president of the United States, was a senator, but he was also an Indian. He was a Kaw Indian, actually, from Kansas. Those of you that don't know, the Kaws are actually who Kansas was named after, the Kansas Indians. So it's interesting, but he was one of those folks, who became well-educated, was obviously, sort of very politically motivated to rise through, the American political system. And, but, in his mind, he was of that generation that thought that this is the best thing for my people, is for us to just be on equal footing with everybody else. And at the end of the day, what does that mean? Citizenship in this country. And I think that's kind of, everything that sort of shoved us forward into 1924.
Exactly. I did find, like you were saying, that Congress thought it was such a benevolent act to bestow, if you will, citizenship onto Indians without their consent, really. And Mr. Snyder, who introduced it in Congress, thought it was the best act ever in history at that time. So what I also found was that there were about 125,000 people in which it was extended to. And Professor Berger, I was wondering, when I read something about birthright citizenship, it was extended to the children that were born. So was it extended to the parents of the children?
So everybody that had been born or would be born in the United States would be citizens under the act. So this would basically be everybody. It would now what did this mean for, like, particularly Haudenosaunee people born in Canada? I believe that 1928 there was a provision for the cross citizenship of Haudenosaunee people born in Canada. under the, the long history of the Jay Treaty and border crossing. I think this is less certain for Native people born in Mexico. So that border does not have exactly the same rights to cross borders, although obviously, there are reservations that cross the border as well.
And also sticking with you, Professor Berger, I was wondering, citizenship is heavily criticized. In fact, Robert Porter says it's essentially genocide through Americanization, in that the right of voting weakens self-determination and sovereignty, because he believes that urban Indians will naturally vote for their interests against reservation Indians as well. And then many natives think it's for assimilation purposes, thus land expansion for non-natives. Can you also elaborate on those concepts, who thought it was good and who thought it was bad?
Yeah, and just to add to what Professor Tahsuda said about the 1924 Act a little bit first, and to what actually Professor Bauer said as well. So the side of American Indians that had been, pretty pro-citizenship kind of started to be, as he said, well, not if it means assimilation. And by the time there was the 1924 Act, there was actually the Committee of 100 to review what was going on in federal Indian policy, and indigenous people were on it, including, I believe, Henry Rowcloud, who was also from the Nebraska, Winnebago, Ho-Chunk tribe, so John Elk's tribe, and Arthur Parker, the son of Eli Parker, who had submitted that petition, and both of the, and they were kind of opposed to an automatic citizenship measure. And in fact, the congressional report on it said, 2/3 of Indians are already citizens and they don't really care much about it, both because it didn't mean any freedom from federal domination and it didn't necessarily mean a right to vote at the time. And a number of indigenous groups wrote in to say, I'm not so sure about this. But today, I think Professor Porter's view is a view that's out there. It also is particularly a view among Haudenosaunee, like Professor Porter. So Audra Simpson, who is, I think, Mohawk, has written eloquently about what the border crossing means, and Haudenosaunee use Haudenosaunee passports and have, not without pushback. I think now it is a minority view because citizenship does not mean that you are not a tribal citizen or that you don't have tribal rights. In fact, that was something that the Committee of 100 did. It had them put into the measure. This doesn't mean that you're losing any of your tribal property rights. And citizenship is, in this world in which so many indigenous people have to live or work or go to school off reservation, it creates, and are so affected by states and federal decisions, it creates a power to have an influence on that decision. So when I saw your question about that, I thought about the 2020 election where folks were looking at where did people, how did they vote, red or blue, in Arizona? And we all saw that, like, northern Arizona and big strip down, and those of us know that's Navajo. And I remember on Twitter, after it was confirmed that Biden won Arizona, a Navajo scholar wrote, Yatahe MFs. He didn't say MFs, but you know what I mean. And so meaning hello in Navajo. So there's a lot of different forms of exercising power and having a voice. And I would think that there's also a powerful view of citizenship helps as well.
Thank you for bringing that into 2020. federal Indian law is so complex that there's not enough time to actually touch on every single thing that has been affected. So in 1940, also, Congress passed the Nationality Act, reaffirming Native people's birthright citizenship. So to all the panelists, beginning with Professor Berger, I would ask, who did citizenship help? And was it positive or negative, if you have anything further to add on to what you just said?
And maybe I'll just briefly, well, I mean, so since, and actually this brings up something that I wanted to mention about that 1924 Act. Just a week difference from this, Congress passed also what's known as the Quota Act, that both prevent kind of closed, so Congress had begun to prevent Chinese immigration to the United States in 1882, and gradually extended this to more and more Asians. And in 1924 said basically all of Asia except like the Philippines, which was still a protectorate at that point, and maybe some, US territories, no Asian immigration, and it's kind of made permanent this. You can only migrate to the United States in proportion to your ethnicity that's already here. So to keep out Eastern Europeans, particularly Eastern European Jews, and Southern Europeans, particularly Italians and Portuguese, which is the reason that my grandmother migrated illegally and had to go to Canada and then migrate legally as my grandfather's wife. So this is not a moment, we are opening this up to the world. It is a moment, as Professor Bauer and Professor Tahsuda said, of, this is not such a big deal for us now. But now I want to say that given the increase in border control since really in that 20th century period, given the increasing importance of voting rights and the extension of voting rights to people without regard or formal regard to race, which was not the case at the beginning of the 20th century, I would say that citizenship is overall a positive, and is still used as rhetoric to undermine tribal rights. And that is a misunderstanding of what citizenship means.
Thank you so much. And Professor Tahsuda and Bauer, when you think about the legacy of citizenship as a Native person, what's important to or beneficial for you going forward?
I guess I'll take it first. So I think that in my view, if we look at it now, I think one of the important takeaways is that we live in a different world than we did then, and I think evidenced by sort of this notion that the fear then of essentially giving up your Indian citizenship for a U.S. citizenship. We know that's not the case, and if you look more broadly now in 2024, the United States is slowly but joining a lot of the rest of the world in being sort of multi-citizenship or open to multi-citizenship. And it's no longer necessarily this notion that you have to have allegiance to one nation, but that you can be a world citizen. So you can be a citizen of 2 or 3 countries. And again, the United States has been a little slower. We think of sort of like the European Union is way ahead of everybody there, but moving in that direction. And so I think that in my mind is sort of what we learned eventually from the Citizenship Act, is that we didn't have to give up our allegiance to our tribal nation and becoming a U.S. citizen. I think that, like other folks, our family members, went through times of discrimination, et cetera, like other people did of other races here in the United States. But at the end of the day, there is something that goes with the citizenship of the United States and your state, in which the laws are supposed to be applied equally to you. And so, at the very least, the notion that when you step off the reservation and you're a U.S. citizen, you're going to be treated like everybody else is of some value. And I think, as you travel around the world, occasionally you have the opportunity to go to places in which it's not quite the comfort of people moving around their own country is not quite the same as it is here. And so I just think in a larger picture, those are all sort of things that benefit us individually. I do think too that I grew up in Canada, and experienced sort of the native experience up there is a little different. And I think there's also something that we have to acknowledge, is that as um, you know, as terrible as it may seem, in some ways, um, we as citizens of our tribal nations have ended up um, better off than native people in other countries, that don't recognize the sovereign rights of their nations, and they have to depend upon just individual rights, so there are some advantages, I think, to us here in the United States that go with that. And so that's being part of sort of this larger system. We could certainly vote to be a part of that, but I think having the ability to rely on the United States laws, sometimes to our advantage over United States, right? But that's something that is not there for a lot of native or indigenous people around the world and in their countries. And so I do chalk that up as to something that I think has been worthwhile coming out of that.
Yeah, I think my colleagues have kind of said some kind of great stuff and kind of added to our discussion. And Professor Berger, thanks for mentioning Audra Simpson. My graduate students are reading that book tomorrow night, so no doubt we're going to have a great discussion based on some of the issues that we've been talking about today. So when I was thinking about this question about who does citizenship help, positives and negatives, I think we have kind of traced kind of a critical narrative of it throughout the 19th and 20th centuries. Professor Tahsuda has just said. Right, this kind of its connection to assimilation policies, and as he just said, right, it's not the same as it was in the 1920s, how we think about these issues. And so I think the way I would look at this again, or ask us to think about it, is to take seriously how indigenous peoples have thought about these issues especially throughout the 20th century. So I really think it's important to think critically and to assess what did the Society of American Indians say about citizenship. Why did they want it? Not necessarily so for the same reasons as reformers. As we've mentioned earlier, like Arthur Parker. Like one of the reasons that I think Arthur Parker and other members of the Society of American Indians wanted citizenship is that they make the argument is, hey, we were here first, right? I mean, it makes no sense for indigenous peoples not to be citizens, especially right in the 20th century, if indigenous peoples were first here. And I mean, I think that was kind of a powerful statement that they were making in the 20th century. And I think that the reasons that they were asking for it, right, is escaping the overbearing nature of the Bureau of Indian Affairs, to achieve and to gain voting rights, and to have kind of access to maybe even local resources that they might otherwise not have access to. Like, I don't know, just like going to hospitals, right, county hospitals, or these things that in a lot of ways before citizenship, is that, say, county hospitals wouldn't accept some California Indian people, for instance, because the county said, hey, you're not the responsibility of the state, you're the responsibility of the federal government, ergo you need to go to a federal hospital. And so there was a lot of kind of roadblocks and that citizenship helps to kind of I think balance out. And I think secondly, the other thing that I would point us to is again, thinking about how indigenous peoples kind of thought about this idea about dual citizenship and how they might kind of articulate citizenship within their own nations. And so, you know, I maybe it's just because it's recent in my mind from my lectures, but we were just talking about the Indian Reorganization Act last week in one of my classes. And if you kind of look at so the Indian Reorganization Act kind of created procedures for tribal nations to reorganize their political structures, usually around a constitution, admittedly coming from the Department of the Interior. But if you look through those constitutions, each tribal constitution has different provisions for determining membership and citizenship within the nation. Even say here within the state of Nevada, the constitutions that I've looked at and that I share with my students, almost every different tribal constitution that were created in the 1930s and the 1940s under IRA have different procedures for determining who is a citizenship of the nation. Right? A lot of it, of course, depends on ancestry, whose one's parents were, but it might be about locality, where you're living at the time and not living and that sort of thing. So I think that Native nations have wrestled with these issues within their own nations and with their own frameworks that I think sometimes it's kind of obscured by this larger discussion about citizenship. And maybe we need to kind of address more and think through and kind of think through again, kind of indigenous politics in the 20th and now 21st century. So thank you.
Thank you so much. And thank you to all of our panelists as we moved into our Q&A. And as we're coming up close onto the hour, I understand if you all need to leave. And what I would ask before you do so is if you've learned anything, please type it in the chat while I'm asking the question that we do have in the Q&A. It is from Krista, and she says, hello, I was curious if you would care to offer your opinion regarding lessons to be had then to now, 100 years later, regarding the 4 million second-class citizens of the 5 U.S. territories where thousands indigenous Americans reside, who are not allowed to vote for U.S. president or have a voting congressional representative.
Well, since I live here and there's always this discussion about the District of Columbia not having a voting representative in Congress, I am very much for self-determination. And so if you have a territory, let's say you would call it a Commonwealth, but Puerto Rico, right? If they, which it seems to be the sway of public opinion now, is that they would like the opportunity to become a state. And I think more power to them. And in the same way, it doesn't lessen their cultural identity as Puerto Ricans to become American citizens, and so the same way it doesn't lessen in any way them becoming a state. In fact, I think it's empowering to them, right? And you're sort of, as the saying goes, you enter on equal footing with the other states, right? So, but then your local government has the opportunity to represent you, in a different way than it does when you're a territory. So I'm all for it. I will say my plug for the District of Columbia is I think that it's perfectly fine. Many nations have capital districts in which the federal capital resides, and it's not part of any state or province. And so I don't have a problem with the District of Columbia not being a state myself. But when you look in that regard, I would say there's not a sort of separate cultural identity like you would find in Puerto Rico within the District of Columbia. And so in that sort of vein too, I don't see that there's anything within making the district a state that would, protect something, like self-determination. So that's off the cuff. That's my 2 cents on that.
Professors Bauer or Berger, do you have anything to add?
You want to go first?
No, you can go ahead.
Okay. I mean, so I think it is pretty complicated, and it's not a question, I mean, so the presidential voting rights, the rights to vote for folks in Congress, that comes, as Professor Tahsuda said, in statehood, not necessarily citizenship. So Puerto Ricans have US citizenship and yet can't vote for, president when they're in Puerto Rico. And I think the issues are different for different territories, and in Guam, I believe it is, the particularly the indigenous people of Guam have come out against citizenship because of concern about what that would mean for their self-governance. So there are legal questions that are different from those faced by indigenous people in the United States, where there is so much crossing between indigenous and non-indigenous territories, and those faced by people in Guam, where everybody's there in one big territory. So I'm not going to say that one answer is the right thing for the people of Guam.
Yeah, I think that's how I might answer that too, right? I mean, I think in a way the question kind of speaks, and the kind of the contemporary issues here it speaks to kind of even kind of the issues that we've been discussing throughout our discussing this morning. Is just sometimes the ways in which indigenous peoples kind of sit in between some of these legal structures. And I think it might be the case of American Samoa. I'm not really sure, but if you're born in America, you're kind of indigenous person born in American Samoa, you still need to get a passport, a U.S. passport, or a passport to travel to the United States or something along those lines, right? So that there's these kind of these odd, not odd, but these kind of difficult, kind of liminal, kind of legal situations that I think people put themselves are located in. But also, I think there might be kind of opportunities, kind of imagine kind of a different indigenous futures here too. It kind of reminded me of that indigenous peoples have historically been thinking about different ways of engaging with the United States. So there was after in the 1770s, 1780s, a treaty with the Lenape, for instance, had a provision that the Lenapes could organize as a group and become effectively a state of the United States and send their own representatives to Congress. Indigenous peoples in the Indian Territory were flouting kind of the same thing in the late 19th and early 20th century. So there might be ways to kind of think through kind of different kind of indigenous political futures in some of these territories.
All right, thank you so much. I don't see any more questions in the Q&A. I would like to give the audience an opportunity to ask them live if they'd like. Just raise your hand if you have any questions. All right, well, seeing no hands, let me first thank the Nuwuvi people for taking care of our land since time immemorial, and also thank our professors, our distinguished experts, for lending us their expertise today. Thank you so much.
Thank you. It's been a pleasure.
Thank you, Carla, for bringing this together, and for the University of Nevada, Las Vegas.
This was great.
Yeah. Thanks, Carla. Good program. Really enjoyed it.
Yeah.
Thank you so much, you all. Have a nice day.
You too. Bye.
Bye-bye.